Hi, this is Chris Addick from the law firm of Addick Curran Steele. At Addick Curran Steele, we provide caring, effective, and efficient representation of veterans with VA disability appeals before the Board of Veterans Appeals, the U.S. Court of Appeals for Veterans Claims, and the U.S. Court of Appeals for the Federal Circuit. Today, I want to talk to you about the Bailey case, a recent Veterans Court panel decision. Some links to this precedent will appear below this video, but if you'd like to look it up yourself, you can find it on the court's website at docket number 19-2661. The decision was issued 6th of January, 2021. Chief Judge Bartley wrote the opinion for the court, joined by Judge Toth and Judge Peach. Judge Peach issued a concurring opinion, which we will discuss. Before we can dive into this case, we need to lay out a couple of predicates. First, the VA rating for prostate cancer generally works like this. While a veteran's prostate cancer is still active, meaning there is no local recurrence or metastasis of a malignant neoplasm of the genitourinary system, that veteran will be rated at 100%. Once the veteran's prostate cancer goes into remission, the veteran will be rated for voiding dysfunction or renal dysfunction, whichever is predominant. Second, this appeal involves the concept of separate evaluations that are separately compensable. Specifically, this term commonly refers to the VA's practice of rating a single disability under multiple diagnostic codes without pyramiding. This concept is beyond the scope of this video, but you can learn more about it on the court's website by looking at the 2019 precedent Morgan v. Wilkie. If you're looking it up on Lexis or Westlaw, you can find it at 31 Vet App 162, 2019. So back to the ratings for a prostate cancer and a VA claim. Here's what happened in the Bailey appeal. The veteran was diagnosed with prostate cancer in March of 2013 and filed a claim to Service Connected about a month later. Within a couple months, the VA granted service connection for prostate cancer and awarded a totally disabling 100% prostate cancer rating while the veteran was undergoing treatment. When his prostate cancer went into remission about a year later, the VA reduced his rating from 100 to 60% based on the predominant symptom of voiding dysfunction. The veteran objected. He had residual complications of prostate cancer that included frequent bowel movements, diarrhea, swelling of the ankles and feet, and lymphedema of the lower extremities. The VA ignored these complaints and kept the veteran's prostate cancer rating at 60%. On appeal to the Board of Veterans Appeals, the Veterans Law Judge, Judge Keith Allen, affirmed the VA's decision, ignoring the full scope of the veteran's prostate cancer disability, writing, quote, "The rating schedule does not contemplate these symptoms/disabilities when evaluating the residuals of prostate cancer. In fact, the rating schedule is specific in that it directs renal and voiding dysfunction to be rated only," close quote. While his appeal to the board was going on, the veteran protected his effective date by filing a claim to Service Connect the lymphedema as secondary to his prostate cancer. The VA ultimately granted service connection for that lymphedema, the very same lymphedema that the board had declined to rate for the veteran's service-connected prostate cancer. So the veteran appealed to the U.S. Court of Appeals for Veterans Claims, seeking an earlier effective date for the rating of his lymphedema on the grounds that it was secondary to his prostate cancer and should have been rated as a residual or a complication in the prior claim. So what did the court decide in Bailey? The court's decision conceded that when rating prostate cancer, the VA is limited to considering the predominant manifestation, either voiding dysfunction or renal dysfunction. The court looked to the implicit language of 38 CFR 4.115, Diagnostic Code 7528, for that interpretation. However, the court made clear that that does not mean that the VA can rate only those two components of prostate cancer. The VA must still rate any complications of prostate cancer that are reasonably raised by the veteran or by the evidence of record. The hidden dispute in this case, what I think this case was really about, was whether or not the veteran had to submit a form to separately claim the complications and residuals of prostate cancer as secondary to the prostate cancer, or whether the VA should consider and rate those complications and residuals of prostate cancer as part and parcel of the original underlying claim without the need for an additional form. Over the past 7 years, the VA has been making a concerted effort not just to force veterans to use standardized forms in their unique claims, but also to restrict its adjudications to what veterans put on those forms. The majority opinion interpreted the interplay of several regulations with the prostate cancer rating, notably 38 CFR 3.155D and 38 CFR 3.160A. 3.155D states that a complete claim is required for all types of claims, and 3.160 states that a claim is complete when it is submitted on an application form prescribed by the Secretary. The court ultimately concluded that the VA was wrong. Complications to prostate cancer should be rated, so long as they were reasonably raised by the veteran or the evidence of record as part of the original claim for prostate cancer, without the need for more forms from the veteran. The court wrote, the VA anticipated and expressly permitted situations like Mr. Bailey's, where a formal claim concerning the primary disability's evaluation is pending, but chose to require the filing of a formal claim for secondary service connection when VA was not already processing a properly initiated claim as to the primary disability's evaluation. Judge Peach issued a concurring opinion, which I think is interesting in the context of other residuals for conditions other than prostate cancer. In her concurrence, Judge Peach proposed a simpler answer. She focused on the phrase any additional benefits in 3.155D2, interpreting that language to mean that if the Secretary identifies a complication, he should consider all potential avenues for compensating a veteran for that complication. So what is this case? What does the Bailey case mean for veterans with prostate cancer claims or advocates and agents or VSOs who have clients with prostate cancer claims? I'm going to go through four things that I think that it really impacts. First, tell the VA every complication of your prostate cancer or your client's prostate cancer. In that original claim for prostate cancer, be sure to tell the VA any complications or residuals that you have even before it goes into remission, but especially after it has gone into remission. And you can tell the VA about these complications and residuals in three ways: lay evidence, medical evidence, and expert opinions. The best course of action, if you can, is to use all three tools. If you use lay evidence, be sure to focus on frequency, chronicity, and severity of the residuals and complications of prostate cancer and their impact on you or your client's earning capacity. It's been my experience over the last 14 years that lay evidence, when done right, can be a silver bullet in your VA claim or appeal. Though not necessary, you can bolster your lay evidence with medical evidence that shows the complications and residuals of your prostate cancer. And if you decide to use an expert opinion, you should be sure to give that expert copies of your lay evidence, medical evidence, and a copy of your VA claims file, or as they're calling it now, an e-folder, being especially sure to include any adverse medical opinions so that the expert can ensure that their opinion is thorough. Number two, don't let the VA cut you or your client out of an earlier effective date. The general rule in a VA claim is that effective dates are the later of the date of the claim and the date the entitlement arose. The VA is really fond of saying that veterans didn't tell them about a diagnosed residual or complication, and that therefore the effective date is the date the veteran told them of the diagnosis. That's not how it works. Don't let the VA redefine the date the entitlement arose to mean the date you told us about it. Your entitlement arises when the first symptoms of a disability cause a functional impairment of your earning capacity, irrespective of any diagnosis that comes down the road. The third impact is this: use a form now and argue later that you didn't have to. The veteran in this case did something really, really smart. He filed a separate claim to service connect his lymphedema, even while pursuing an appeal on the VA's failure to rate that lymphedema as part of his prostate claim. He used the form, and then later, after he'd won the claim for service connection, he argued that he was entitled to an earlier effective date for the rating. That's a really smart tactic. Number four, consider having an attorney take a look at your VA prostate cancer rating. Now, I don't really believe that veterans always need an attorney. I believe that most veterans can file, prove, and win their own VA claims so long as they're given accurate knowledge of how to do so. However, There's times when it makes sense to use an attorney, and the rating of prostate cancer may be one of them. Attorneys see dozens, hundreds, and sometimes thousands of VA claims. So we've seen a wide variety of scenarios play out. We are aware of residuals and complications of prostate cancer that you may not know about and that you may not have even thought about. And we likely know which residuals and complications are more likely to have a substantial impact on your total impairment rating. I'm not saying that you have to hire an attorney or even that you should hire an attorney. I'm only saying that it makes sense to think about talking to an attorney to make sure you're not getting lowballed by the VA or to make sure the VA is fulfilling its duty to maximize your VA prostate cancer rating. If you're a veteran who believes that you've been underrated for your prostate cancer, or that the VA is ignoring additional residual symptoms or complications of your prostate cancer, or if you're appealing a VA or BVA denial of service connection for your prostate cancer, please consider reaching out to the law firm of Added Kerr and Steele. You can visit our website at www.bvaappeals.com and request a consultation with one of our attorneys. Thanks for your time. I look forward to seeing you on the next video, and until then, stay safe.